This, what do you use? No, I've had tetanus. You get tetanus diphtheria, and I also get pertussis. I get the called Tdap. Yeah, I take it about every 5, 7, 8 years. It's supposed to be every 10, but
I don't get it because
you know.
$35.
How you doing?
Doing good.
Well worth $35.
How are you? You're fine.
Attendance today.
Jack left me. We're going to call the Arkansas Medical Marijuana Commission meeting to order Wednesday, July 25th. It's about 4 o'clock, 4:01. If you take a minute to review the minutes from the last meeting dated July 12, 2018, and I'll take a motion to accept or correct.
Motion to accept. I'll second.
Any discussion?
No.
All in favor?
Aye.
The next item is the update of the amendments to the MMC rules that we requested. And you should have a copy of those. Jenny, you wanna?
I actually don't have a copy provided in here, but it is the same. It's the amendments that you reviewed last time and voted on. We presented those amendments before ALC last Thursday, and the executive subcommittee of ALC, and the subcommittee went ahead and voted to approve all of those amendments to the rules as emergency rules. They've been filed with the Secretary of State, so they are now effective emergency rules. They will be effective for 120 days. We are also simultaneously promulgating the traditional rules, and those will be effective. Those will go before full ALC and hopefully will be effective somewhere between 30 and 60 days.
Okay.
Sounds good.
Any questions? So, the next thing is discussion of the holding cultivation facility applications in reserve for 24 months. Under that is a proposed communication to the applicants.
Yes, so as...
That was one of the rules?
That was
Yes,
one of the rules.
that was one of the
Mhm.
emergency rules. One of the emergency rules was to authorize the commission to opt in or elect to hold over those applications. Now that you have the authority to do so, if you would like to do so, you can vote to adopt or hold those applications and scores. Or you can discuss or...
I thought we kind of discussed that and we
Yeah.
agreed. So I'm going to go on, I guess we can have discussion, but I'll make the motion that we approve that hold for 24 months.
I thought we did discuss it and voted.
We did, but
This
you're
is
saying we have to
merely
kinda
a
do it again. It's more of
A formality,
Now we
okay.
have-
The
We
rule
voted, now we
wasn't-
have true permission to,
Yeah, we
Okay.
couldn't do it because it wasn't in our rules.
Now it's been approved, okay.
so I would just move that we,
I'll second it.
Any further discussion on it?
I had some discussion on the communication, but we can vote on this part first.
Okay. All in favor?
Aye.
Aye.
Okay.
So on the communication, and this is my error, I failed to print this out and put it in your packet. What I have prepared though is just a short letter to applicants notifying them first of the rule change with kind of a breakdown of what it means. And then second, notifying them that they have, if they wish to stay in, if they wish to keep their scores active, no action is required of them. If they wish to withdraw from the process and receive a refund, they may do so. All they need to do is submit that request in writing, either via email or traditional mail.
And do we tell them, like overtly tell them that, kind of give them the warning that, hey, you got to keep your proposed location, and I mean, all of those things have to stay the same, just so they know that it doesn't mean that they automatically get it if somebody else has leased the storefront or somebody else has done something else.
Right, eligibility must be maintained.
And so we're clearly communicating that kind of thing.
Yes.
Okay.
With your permission, I can,
I would have a motion that we authorize Danny or authorize ABC to send out the communication on our behalf.
I would like to review, can we review it before it's sent out? Yes, I think.
Okay, that's
Yeah.
fine.
do you want me to go print it out and get it now, or do you want to?
No, we can review it
Okay,
later.
I
But
just-
yes, you can send it to us. I mean, we can review it later.
Absolutely.
Yeah. We need to acknowledge our legislative leaders that are here. Thank you for being here. I'm sorry I didn't look up earlier. I appreciate it. Next, we're going to discuss and review the staff decisions to disqualify the cultivation facility applicants.
Yes.
So-
So I have prepared a number of things for you in these packets here. One of those things is a spreadsheet. It contains the 13 cultivation applications which were disqualified. It also includes the date which they submitted that, their status as disqualified, the date they were notified of this disqualification, and the notes of why they were disqualified. I also prepared a memorandum for you addressing one specific applicant. A couple of you had questioned in our last meeting that there was one applicant who was in the unique position of being disqualified after scoring. So there is a memorandum with some background information on that, because you guys had wanted specific information. On that note, I've been made aware that you all have been contacted and provided information by that applicant to your personal email accounts, and I believe also in person here today. At this point, I feel it's imperative to caution the Commission against discussing or considering any newly received information. No other disqualified applicants have been extended such an option to submit or present anything new to the Commission or have that considered past the deadline. And to do so for one would require this Commission to do so for all. I also do want to remind the Commission, we did have lawsuits about this last fall and in the winter that were dismissed, that specifically dealt with the issue of submitting things past the September 18th deadline. I'll let you guys review everything that I've put in front of you.
I mean, I've read it, the 3-page, I think it basically comes down to an issue of ownership and whether or not that, if that can be clarified to define the rest of the ownership, and whether that's clarified to satisfaction that it would have been a, still a viable applicant once that's clarified. Obviously, it was a very good applicant, or we wouldn't be having a discussion. So so I know, of course, I can't access my email, so I didn't read any of the. They just handed me the thing, but I haven't read it because.
That is exactly
Okay.
what I sent.
So what application, are you discussing all of these right now?
No,
or you-
no, just the
You're
one.
looking at the one that we're going to do?
The one we
Yes.
graded. The others, I think, are
The
fairly
other ones
explainable.
met qualifications, so the one that we did not disqualify until after it was scored is what you're discussing, correct, Dr.
Yes,
Ramon?
that's what, I mean, to
For
me, that
clarification.
seems to be the only
Okay.
issue, is that, is the Carpenter Farms application that we scored and then was thrown out in arrears. And it seemed like it was an issue of ownership on a particular LLC, listing the complete ownership of South Street Medical Holdings. And I guess the issue comes up, as you just said, I mean, if that can be clarified and that ownership would still meet criteria, then I guess it comes down to a vote of, do you go on and give them their score? Or I guess the downside of it is if we do, then what's the litigation risk of
Well, I think just from, there has been litigation about this previously. We open up the unknowns when we start saying, we'll take new information that clarifies something that wasn't in the application to start with. And then you kind of reopen up all those other applicants to say, well, wait, I was trying to give more information and trying to fix some of these other things. And, you know, where I think we have to rest is our rules say, this is what you have to do. The question is, did that get done? And even though we're talking about ownership interest versus not providing, let's say, some of the forms of, you know, residency or, you know, the proofs of things, those are all still very, I mean, those are just kind of the check the box part of the application.
So-
If they aren't done, then
So, my
there's
unders-
nothing to really.
My understanding is that did applicants who had information that was not clarified have the opportunity to clarify the information? And if that was the case, that this application was not notified prior to the deadline because they were notified that they met all the minimum qualifications. That's my real concern about it. So was there a period that the applicant could have clarified that information if it was caught in a timely fashion?
No, it was, if it had been caught during the initial review, which took place, I believe, on let me reference I believe it was September 28th.
Because for
September 27th is when let me back up.
when was the application submitted?
Let me go ahead and give you
Okay,
all
yes,
the
thank
information
you.
and the dates. The application was submitted on the 15th of September. When applicants submitted their applications, there was a checklist in the office that the person who received it went through and just checked off, do they have their section A, B, C, D, and E? And do they have the documents that are required to go in there? This was not any kind of substantive review. You guys have seen how many applications there were.
Right.
There were 300 applicants that came in about a span of a week. And so there was only time to do the initial check. Yes, you have the items that need to be here, or it appears that you have the items that need to be here. You have sections or schedules A through E.
So if they didn't
At
have
that-
something,
Sorry, go ahead.
so if they were missing something at that point, would you let them know?
Yes, if there was a Schedule
were-
E missing,
Well, we did
Oh.
have a cure period.
Right.
Yeah, that's what I'm saying.
Yeah, we did have a cure period.
Right.
The week before, it wasn't,
I think it was
Like 10.
but we required 10 days.
how long was the
Right.
cure period?
10 days to
Wasn't it
do
10
it.
days?
cure period was dependent on when an applicant submitted their application.
Right.
Anybody who submitted their application on the 18th, the deadline, there was no cure period. If somebody submitted their their application, say the first week of September, there was an opportunity
Right.
for staff to review and cure up until the 18th.
Did
The
this
fif-
application submit in time for that?
It was submitted on the 15th.
So it
which
did
fell-
make that date?
It did not. Realistically, it fell on a Friday, so it had the intake form done, but the sheet here says that it was not, the substantive review was not conducted until the 27th. That went in the order just based on when applications came in. This application was the 120th application received, so it was in 120th place to get reviewed. So it didn't get reviewed until September 27th, at which point this error was not identified. That said, that was almost 10 days past the deadline. So at that point, had it been determined, no, the applicant still could not have submitted anything to rectify or cure this situation.
But, so I want to ask one other question, to make sure I understand this. So let's just use, for example, Medicus, Arkansas.
Yes.
I know they put on the 18th. Let's just say they submitted it on the 12th of September, and they were missing, they didn't have proof that they were an Arkansas resident. There was an opportunity for them to come back, and you'd say, hey, you're missing your birth certificate, or that you know, proof that you're a resident here. They could have come back and provided that, and the application would have gone through. Is that, I mean, they had a,
Hypothetically, no, on the 18th, no.
No.
no, but if they
Because-
had, I mean, it could be anyone. It could be Joe's cultivator, right? So Joe's Cultivator puts an application in on September the 10th, and they forgot to put in their driver's license.
Yes.
So you would call Joe's Cultivator and say, hey, everything looks good, except we don't have a driver's license, and they
So
would
you're
have the opportunity to
disqualified.
pull
If the
it.
application came up for, if the substantive review had been conducted on or before the 18th, and they brought something in on or before the 18th, yes. And there
Okay.
were situations of people who submitted very early on, who were perhaps missing things like that, who had
Okay.
that opportunity. That is largely because they submitted it very early on, and there weren't very many applications, they were first in line for review.
And didn't we, it seems like, and I don't have my rules right in front of me, it seems like there was like a 10-day period. So in other words, like if you wanted that type of review done, you had to back up from the 18th to like the 8th.
The 10 days I
Isn't that
think
correct?
you're referring
Yes.
to is that
So-
ABC had 10 days to conduct this substantive review.
Right.
From the time it was received.
And so in order for somebody to theoretically have time to fix something, because I remember thinking in my mind when we were all just sitting around waiting for these things to come in, I think I may have even like tried to contact somebody to see how many applications did we get, and it was like on the 9th or 8th, and it was like really didn't get any, there wasn't anything to speak of, and I was thinking, well, that's stupid. Why didn't you do it with the 10-day, enough time to cure it? And I think that's the date we've got to focus on, is if staff has 10 days to look at that, you're out of time once you get past the 8th of September. And I think that's how we've got to look at that, because trying to say I submitted on the 17th, you didn't tell me on the 18th for me to fix it, there's no way. I mean, there's just no way to do that, which is why the 10-day period's there.
Well, it is a
It's-
different, it is a little bit different situation, because they did make it through the first,
They told them something.
I mean, they got through, we scored it, obviously. I mean, I guess basically the question is, does this applicant, do we give it the opportunity to clarify the ownership? And if they can clarify the ownership properly, then we put them.
We can't give the opportunity for clarification this late, because then you're gonna have, however many on this sheet wanting to clarify too, that they had a government ID. But to bring up clarification, we can't do that now
And it's
unless
a
you
whole-
see anything different.
And it's a whole, I mean, you can look at like application number 23 or 43, right? They turned theirs in on the 12th of September. So they turned it in 3 days earlier, and they failed for proof of residency from all the potential owners. So it gets real hard to say, in my mind, unless that date submitted is prior to September 8th, then they were taking that risk of there's no substantive review. Did they have all the sections? And maybe that would be if they were wholly missing section, B out of their application, that might be a different question. But they had all their sections, it's just what they said inside the sections that wasn't up to the minimum criteria that we had previously set.
I'm just so confused. Because this application, based on the review, met all of the qualifications to go on to scoring. So they didn't even fall in this category.
But it shouldn't.
Let me see if I can give you an example of something different that would be along the same lines. If hypothetically I was visually impaired, perhaps completely blind, or legally blind at least, and I went to the DMV to get a driver's license, and I checked a box that said, yes, I'm legally blind, and I don't have corrective lenses that remedy that situation. If the clerk at the time mistook my check mark yes as a no, I'm not legally blind, no, I don't have visual impairments, and gave me a driver's license, but the next day she came in or her boss came in and discovered the mistake, at that point the DMV would come back for my driver's license, because whether or not there was a mistake made at the time, I'm missing a requirement for that. I think even though it's something completely different,
Well, I see your-
it's kind of along the same lines. Whether or not it was missed initially, it's one of those things that just, it precludes, it would be, the
So the-
MMC rules and regs and the Arkansas Constitution require that all ownership must be disclosed and verified. It doesn't grant any authority to this commission to waive those provisions. So to do so would not only be in violation of the commission's rules, but also the Arkansas Constitution.
Yeah.
That might settle it right there. I mean, I think it's a unique case because they actually got through and it actually was a very quality application. But I mean, if it's a legal issue that we just can't, then I.
Well, and I would say, I mean, the part we scored, obviously we all scored it well, but.
Yeah, it's obvious
but
of quality.
I mean, you know, the stuff that we were provided, I would not accept that as quality work because it is not completed well. But this isn't something we were given because this is the initial part. Because I can't draft somebody an LLC that has ownership percentages like this. It wouldn't work. So I guess I would just say, yes, parts of the application got good scores, and that's great. But the whole application has to rise to the top, and this is the first time we've been given this part of the application because normally we didn't see these
Yeah, that wasn't
particular
our-
pages.
Wasn't our thing.
And so it would have been impossible for us to understand that was an issue because we didn't see this. But seeing it today, it would not receive, if I had to score this, I realize it's not a scoring thing, it wouldn't pass muster.
See, my sentiment is to put them in their proper place because they was a quality applicant out of the ones we did. But if it's a legal thing, then I mean, there's no reason for us to. I mean, I'd like to see them be number whatever they are, 7th, 6th.
Yeah.
I mean, I'd like to see them get it because I think that's a great application. But if it's just going to be a legal issue that we can't jump over that hurdle, then that kind of makes it a moot point, no matter what we kind of think about it.
Any comments? You finished it? So, based on this being a legal issue because of the fact that it did not meet the time, if it was submitted on September 8th, it would have met the
cure period.
the cure period?
Are you saying hypothetically?
Yes.
It's possible, but I can't speculate and give you an answer, yes or no, that it would have. Are you asking if it was September 8th that it?
Right.
I'm just wanting to know. You said, was there a period?
There was a 10-day business period. So, yes, potentially.
So is it, and I haven't looked at this, I can't get my email either way, but is the ownership definable? I mean, if they resubmit as the ownership, would it hit criteria if they had submitted it all on the front end, or do we not know? I guess we do not know that.
ABC staff was unable to verify, and that's the problem.
Yeah. I mean, I think it ends up maybe just being a legal issue. I mean, to me, if they got the points, but if legally they can't, it just like the others you said, if they didn't qualify, they didn't qualify. But then I think it ends up being a legal issue and probably not even up to us. I mean,
So
There you
the sheet we were provided, it says the date submitted on each of them, the earliest date was the 12th.
Yes.
So were there any applications disqualified that were received before the 12th?
No, this is the extensive list of all cultivation applications.
Okay. I just want to make sure I'm understanding that.
It has to be prior to the 12th.
I'm not sure if there were dispensaries submitted and disqualified before this.
Just,
But-
but
But
cultivation
talking about
facilities.
cultivation.
Correct.
Yeah.
There was one on the 12th, one on the 13th, and then it went to the 15th. But there were, anyone who submitted before the 12th qualified. Is that what this is telling us?
Yes.
Is it prudent, I mean, is it even possible if we just say, well, let the score, but, I mean, they can just take it up with the legal, I mean, I guess they just need to take it up with Amendment 98. But it sounds like that's gonna hold up, so I don't think there's anything, doesn't sound like anything we can do about it, so.
At this point, I guess the question is, unless the commission's gonna revive it somehow, it's already been disqualified, correct?
Yes, it's been disqualified by ABC staff. What the commission has, is the commission.
We didn't disqualify
The
it.
commission has
And
the
I agree
final
with that.
authority.
That's what I was trying to figure out.
To either ratify disqualifications or to overrule disqualifications. That authority lies with the commission.
Wait,
So-
that authority rides, but I thought you said if we, it's all legal stuff, so I'm absolute amateur, right? But, so if we ratify the score and say, fine, the score holds, and then just defer it to the, you know, if the courts come in and say, well, no, it doesn't hold because of Amendment 98, or should they just go to the courts? And do
I
it that
think
way
we
and
should
come back to
ratify the
us?
score and let it come back.
Yeah,
Because I scored it, and I'd like to make a motion that we ratify the score.
'Cause yeah, then they can just take it up in court and then,
If I may clarify, when I said the commission has the authority to ratify, the commission has the authority to ratify the decision to disqualify.
right.
The court, or the commission also has the authority to decide, no, that application should not have been disqualified. We want to overrule that decision by ABC. That said, that is any disqualification. When I'm referring to the specific application of Carpenter Medical Group, my earlier caution to this commission stands. To do so would be in violation of your rules and also a violation of the Constitution.
so should they just challenge that?
So,
There's- Madam Chair, I'm sorry.
Yeah, that's why I'm
That's
confused
a
on the legal
little,
part.
that's a little heavy, I'm just saying, we scored the application.
Yes.
And I'm going to put a motion that we keep the score of the application.
So you are, said a different way,
Yes. Go ahead.
you are saying we are going to reject the disqualification
Right.
of ABC for application 120.
Mhm.
Is that, I'm just trying to make sure that's what we're talking about.
Right.
Okay.
I mean, can they not just take that? Could they, just for discussion on that, because I agree, I'd like to, I mean, they had a great application. I don't want to do anything, I mean, if it's going to be illegal, can they take that to the courts and then come back, and if the court says,
But we get
Yeah,
an
it would be
injunction on the
qualified, or-
whole process again.
no, we can't do that, but.
I think their legal recourse is for them to sort out with their own personal counsel.
Okay.
Yeah.
I think,
Yeah.
I don't
however, the
think
legal,
that's-
Is that what you were saying, that we get an injunction on the whole process again? I just wondered.
I mean, it's very possible we could be, we could find ourselves,
We
this
need,
commission
yeah,
would
we
have-
need to cease discussion, and if anyone want to second this,
I'll second it and let it go to the, I mean, I
thank
guess
you.
we'll go to court.
So a motion is on, and it's been second. Now you can discuss it.
I mean, I think it ends up being more of a court decision than even our decision if it's, I'd rather see it go, but I see
You
the
know,
whole injunction
This is
thing.
a problem I have with this whole thing, and I may be wrong, and I do not know the legality the way you guys do. I'm not a lawyer. But this application met all the qualifications, scored and everything, and then we get the scores and the application's there no longer. And no one's talked to any of us as a commissioner, no one, about this, why, you know, and it just bothers me for some reason. And now we're breaking all these rules, we're breaking the law. We scored it. We were given the applications. We saw no names. Everything was, you know, taken out. We're given all these applications. We reviewed them and we scored them. There was one application that was scored that was not there. We didn't know where it fell or anything. So, you know, I think ABC can, I mean, I scored it and there's a motion on the floor, and whatever legal needs to be done, I think it should be done.
If it's a legal hurdle we can't jump over, then we just can't jump over it. That's the end of that. But if it's from a standpoint of it was a
scoring
great
it.
application, we scored it, we went through the rigmarole. If they can clarify the ownership, and that's not illegal, you know, based on other people got the opportunity to clarify issues if they turn it in on a certain date. But this is truly different than anything else because it actually went through. So I don't know how much.
That's my only
How
problem.
much you know, they didn't turn in by September 10th where they could have had it, you know, looked at and kicked back.
When was it turned in?
The 15th.
The 15th.
So it wouldn't have hit that criteria, but my sentiment is because we scored it and it was a viable applicant that, I mean, I'd rather some law people figure that other part out if they.
I agree.
If it's just if it's illegal not to, if it doesn't pass Amendment 98, because in the same breath we have that and I circle that part where you know, and you said both, and I get that when you talk about law stuff, it's both. It goes both ways. The final decision concerning whether or not the staff's findings were accurate in determining whether or not the minimum qualifications were met rests with the Medical Marijuana Commission.
And I guess, I think
And if it can be-
the commission faces two problems. One, if we bring this application back for something that was in a minimum criteria that wasn't
But
provided.
we didn't take the application away. They didn't disqualify the application till after we scored the application. All I'm saying is that I've placed a score on an application that was qualified by ABC and then disqualified after we scored it.
And while I'm real sensitive to that, and I don't want to score any application that isn't in the,
Right.
that isn't in the contention for everything, because, you know, as we understood it, we were getting, these have all passed
Right.
the first, you know, the first hurdle.
Mm-hmm.
The problem I think we have is if one of these other parts, you know, we could have had a top 5 applicant in the other 12.
If
We
I
don't
scored
know.
them, if I would have scored one of those, I would say the same thing. If they met the minimum qualification and ABC passed me that application, I would say, I scored it and that's the score that I gave it.
And if we'd have scored it and it was number 50, then it's all irrelevant. But this actually ends up being relevant because we all scored it and it actually.
But I guess the point would be, if you had given me these pages to look through, it wouldn't have gotten the score.
But you didn't
that it
get those
got.
pages on any of them. I mean,
Right.
I bet you can go through every last one of these applications and find something wrong with them. I'm sure. If you nitpick every last one of them, I bet you will find something. And I'm telling you, reading them, some of them I don't even know, you know, I'm just saying that we scored the application, there's a motion on the floor, it's been second.
Sure.
And, you know, we scored the application, and that's what we were supposed to do.
It is unique because this is the only one
Sure.
that, I mean, we can kind of compare it to others, but the reality is this is the only one that we scored. And it had a solid score by all of us, enough to hit, I guess, 6th or 7th, which makes it very relevant. And to just throw it out, I do have a problem with that. I mean, the legalities, if that throws it out, well, that's.
Let the
There's
legality
nothing I can do
throw
with
it out.
that because but from a standpoint of, did they have a great application? Yes, they did. And if there's an issue with the ownership, or if it's too close to a church or whatever, I mean, if it is, then you throw it out because it just doesn't qualify. And that stuff should be easy to prove at the end of the day. You look at
And so
you
should
walk down how
ownership.
close to the church and you do
Yeah.
it. And from our standpoint, that really isn't our job. We're not the legal, we're the commissioners. This was a great application,
And we scored it.
and we scored it. I guess that's my issue with it. And it's irrelevant what if it legally it doesn't pass it and you get through, then it doesn't, but.
But legally, you could do it either way. You know, if we add it, we're gonna get a legal challenge. If we don't add it, Mr. Carpenter over here can file a legal challenge against us.
Well,
Because
I say we just do our job. Our job was to score.
Score it, and we scored it.
It was, it's a relevant, it was a relevant application based on the quality, based on all five of us. I think we should hold the score, and then if there's a legal reason to disqualify, then let the lawyers figure that out. But I think that's what we should do.
How many of the applicants that we graded were given we call it a second review? How many were given that?
The substantive
The,
review.
The
the
substantive re-
substantive review, every applicant. Every applicant that was, I'm sorry, did I misunderstand the
No.
question?
Well,
I think
So-
you mean prior to the deadline date. of
No,
the 18th.
no,
Or so-
no.
It's after
Oh.
they,
yeah, so this was caught
after it was scored.
after the scores were in. How many were all the applications given this second review?
Okay,
what you're saying.
so an actual review, once applications had been scored.
Correct.
As the scores were coming in, there was a pretty obvious pattern of where the top 10 were looking to fall. At that time, ABC staff pulled those top 10 for a number of reasons. One of them being, if you remember some of the meetings last fall, FBI background checks came up for discussion. An FBI background check typically takes a minimum of 60 days to return, and some of them took much longer. So one of the things that was checked for was some of those background checks did not come in until January. One of the things in checking the top 10 as they came in were, did we have all those background checks in, and did they correspond to all of the owners? At that point, since staff was going through ownership, this discrepancy was determined.
So we graded 85, and so there are 75 applications that we graded that did not go through that.
Mm-hmm.
And so we don't know
Where they fall, right.
whether they would be disqualified after that review or not.
Possibly.
And that's what I'm saying, is it has to be, it just has to be fair.
I say
I mean,
the score
it just
stands. Let them, if they can qualify
them
the ownership
qualify it.
and it hits criteria, then it becomes a legal issue. But I think we scored it. It's a great application. By all rights on all. I mean, no one gets through without all five of us thinking it's a good application. So, and if they can't prove the ownership and it's a problem, then you throw it out, just like any of the others. If it's too close to a church, it's too close to a church, then it's simple. It's not, it doesn't qualify. If they do the ownership and the ownership doesn't fit criteria, or it disqualifies it, then it's disqualified. But
Disqualified.
I think,
So at this point, regardless of position, we've done a second review on 10 of 85.
Approximately 10, yes.
So we've got 1 out of 10 there that was disqualified, and we don't know how many of the remaining 75 would be disqualified upon that review.
At this time, no. That being said, none of those remaining 75 at this moment are next in line for a license.
But it shouldn't
Well-
matter where you fall. It shouldn't matter where your number falls. The same thing should be done for every application. So
And
you
if
got-
any of those 75 were to fall in a position,
doesn't
they would
matter,
also
though.
be reviewed in the same way. At this point, all I can do is caution the commission. If you have direct questions, I am glad to answer them, but this is
And
this
it's
is
not,
decision
Danny,
for
we're
the
just,
commission.
we're just trying to make the decision that we scored an application, and that's the motion that's on the floor. We're having a second on it. And you guys want any more discussion on it?
Well, the only thing that I would ask, or it's really back to Dr. Rahman's comment, is that he mentioned number 50 may be irrelevant, but number 50 may really be relevant because we don't know, based upon a second review, how many of those between them in the top 5 would be disqualified.
To me, it becomes relevant if you're in line to get a license.
It does.
But I see your
yeah.
point, do them all, but I guess that's what my term by saying relevant is, meaning that if only we have 5 that are gonna get a license, we have 3 more potentially over the next 24 months could be awarded, those 3 are in play for a license, that's definitely I mean, that's what I mean by relevant, it's just that they could potentially get a license, and I just think we score them. I would let the legal people do their legal thing, and they can confirm whether the applicant passes criteria, minimum criteria or not. And I don't see, if it doesn't, it doesn't. That's not up for us. We didn't determine that in the first place, but it seems like it's still undefined. I mean, there's a question about the ownership that should be a solvable question. You just simply go to the applicant and say, hey, there's an ownership question, we need to see the owners.
I just disagree.
That's why we're here, sir.
That's
But-
why
and
we're
that's
here.
why we're here. That's why
That's
we're
why
here.
the
Well,
committee-
yeah,
all
just
get-
got-
we all
that's
get
why
an
it's
opinion.
commission, and that's
We
why
all
it's,
get a- we
If
all
we
get
were
a
gonna
vote.
agree, then we just need to be one of us, so that's,
Sure.
I think that's
you have
probably
anything?
healthy.
I think. You have any more comments? Let's call for a vote.
Say
All in
no.
favor?
Sorry.
Okay. We're voting.
Oh,
That the score goes in?
yeah, I'm a no.
I mean, yes.
I'm a no because of the constitutional issue.
I'm a yes. I think that's a separate issue, but
So, I mean, I think we still have to address the rest of them too.
You do still have to
Yeah.
address the rest of the applications.
So I guess I would make a motion that we accept the disqualification of the 13 applications which we were given in our packet today. So we accept the recommendation of ABC staff and disqualify the 13 applicants.
Okay.
do we need a second?
I hadn't heard one yet.
Any further?
I'll second it.
Second. So are you counting the one that we just voted, so the other 12?
I'm counting all of them at that
Okay.
point.
Any other discussion? All in favor?
Aye.
Aye. So you have 3 ayes. I guess we have voted. Okay.
Yeah, I vote, yeah. I'm a yeah.
Discussion.
I mean, yeah.
You didn't have a choice after that, huh?
That's right.
Discussion of hiring an independent contractor or consultant to score the dispensary applications. So, we have proposed scope of work.
Hello.
Hello.
We've got David Withrow back with us from the Office of Procurement. Over the past week since we last met, and I draw your attention, in your packets, you've got some items that we have worked on that would go potentially into a scope of work based on recommendations, concerns that you all expressed in the last meeting. And David is here again, and I'll let him begin to sort of explain the path through procurement that we've discussed that would seemingly, if it goes well, be the quickest method through the procurement process to get a third party to score dispensaries, if that's the way you want to go. So I'll let you go first.
Well, good afternoon. We, based on the discussion that was had here 2 weeks ago, we were looking, as we explained then, for what was the most time efficient way, based on the conversations and what we were informed were the needs of this commission. And so we explained, myself and the other OSP attorney who was here last time, explained that cooperative purchasing was the most time-efficient way to go about it. Since then, based on the discussion that you all had, we explained that we could come up with a scope of work or a statement of work to help us in the solicitation through the cooperative agreement. And that is then what has been provided to you, taking in your concerns in the discussion that was had that afternoon. The way that the procurement would work is that in looking at a cooperative agreement, we tried to explain it last time, but essentially a cooperative agreement is a government entity that has an agreement in place with a list of contractors, and it's an umbrella agreement that then different government entities, in this case the ABC and this commission, can access, can kind of sort of plug into or piggyback off of some of the solicitation that's already occurred, and thereby ensuring that the contract is competitive, it's been competitively bid. We have to ensure this complies with Arkansas law and all of this. Then, having done that, what would happen is that the statement of work would go out to a list of these pre-qualified vendors. These vendors would be under health services. So these are vendors that would have experience in health services, and we discussed whether that needed to be exclusively cannabis, but that's a very difficult thing to do, because then you're getting into a much different type of solicitation process where you're looking at very specific qualifications, very narrow qualifications. So again, in time expediency, the best method probably would be to ensure that it's under the right category, health services in this case, and then put out a statement of work saying this is what the commission, this is what ABC is looking for, and then based on that and ultimately based on price, the selection would be made. So then in the statement of work, this is the statement that says, here's what the commission, here's what ABC is looking for. And that's what you have before you. I don't know if you want to go, if you want me to go down it line by line, or if you want to have a moment to look and see what questions you have. But again, we were attempting to take in the comments, the concerns, the discussion that was had 2 weeks ago to ensure that the statement of work would reflect what this commission's thoughts were on the matter.
Yeah, I think, I've read it, but I think they need to have medical expertise. It does not need to be exclusively cannabis. I mean, there's too much bias within the cannabis industry to the recreational bent and things like that that really need to be, there actually needs to be some voice against that. So I think medical is fine, but it cannot be some exclusive cannabis. Plus, if it's exclusively cannabis, there's a high percentage chance they know somebody with their finger in one of these applicants, because as we reviewed these things, most of the applicants had someone from Illinois, New York, Colorado, California. To me, it would be impossible for someone in the cannabis industry not to know other business entities, maybe some guy from Oregon that they're friends with that has an applicant here. So I think it cannot be an exclusively cannabis thing.
And the statement of work as of now does not have it exclusively cannabis.
Okay.
I was trying to state the opposite, actually, that
Okay,
it is
that's-
not that narrow.
And I would add a clarification. When we were discussing this, if you'll look at that third bullet point, it says the MMC very highly prefers a diverse scoring team. It's patterned after you all, in that we have medical, pharmaceutical, we have government relations, and we have a legal representative. Since we want there to be 5 scores so that the range of scoring is similar to what you anticipated, we put on there a horticultural, agricultural, or cannabis representative. So the way that it was written out in some mock-ups that we looked at, it was the first 4 that mirrors the makeup of this commission, and then as that 5th one, because we have 2 physicians on this team, to have somebody that might have some experience with growing, either just any type of horticultural or agricultural experience.
And they can mimic the 5 scores, because that
Right.
is so important, because, I know despite all the BS out there, the reality is, each one of us is only 18% of any vote. The other 10% is bonus points, which were irrelevant to what we thought. So, 18%, you can't do anything, whether you have a bias, be it conscious, subconscious, doesn't matter. None of us had the ability to grant anyone a license. It had to go through all 5 of us, and that is, mathematically, to
Right.
prevent corruption. That has to be there.
And so that's in there. The must abide by all the directives of the MMC regarding the scoring process, confidentiality, and security. The thought would be that they take your existing rubric that you have, the points available, and they score it based on your application, your point systems that you voted on and approved. It's just 5 different people standing in your shoes. There was one other thing I wanted to point out to you, the top one, because it's not really fleshed out in the sense of how we discussed it or on here, when it comes to conflicts of interest. So the thought is that we would run a list here, because if you guys aren't going to score it, confidentiality really goes out the window, the need for it, because it doesn't matter if you know who's on it at this point or anyone else. So we would run a list, and we can do this really easily, of applicants, stockholders, anybody that has an ownership interest in any one of these dispensary applications, and we would provide that with the request for the bid, so that they would have a list to check for conflicts, and when they turn in the bid, they would have to certify that they don't have any conflicts of interest with anybody on that list. And I correct me if I'm out of line here, but I think if they had any, they wouldn't qualify under the scope
Correct.
that we're writing.
That's right. And then the individual members of the scoring team also then subsequently would have to do the same, would have to certify that there are no conflict of interests.
So we're saying that there must be at least 5, or must be 5 by the 8th bullet point down. They can't have less than 5 people scoring this.
That's right. It would require five scores.
You got to have that.
Well, I just want to make sure it's explicitly clear to anyone applying that if you don't have 5.
Right.
Have you looked around? Is there any potentials out there that would take something like this?
OSP has taken a look at existing cooperatives, and the answer is yes. There would seem to be some leads, some good opportunities. I'd be hesitant to specifically name which cooperatives because I have been privy to all of those conversations, but the answer is yes. There seems to be certainly a couple that would have health services and consultants of this nature that it would seem that would be a promising list.
I think some of this honestly goes back to, are we going to send it out and let others score it, or are we going to score it? And I think we've almost got to have that discussion. Do we want to do that, or do we not want to do that? And at that point, then we've got to look at what the scope would be.
Mhm.
I, for one, am not a fan of shuffling off my duties that I signed up for to somebody else to do what I can do. And that's kind of, I guess, where I fall on it. And so I appreciate what's happened here, but if we're going to send it out, I just don't think I can just whole hog bless what comes back. And the issue that comes then is if we say, okay, we could revise the scope to say, give me the top 8 in every zone, but then we've still got to go through the top 8, and we're duplicating work and doing things that I think we get hard. It'd almost be easier just to do it ourselves in the first place.
Any other comments? My problems is, conflict of interest first, the legality of all of this, and even if you scored, it may not count anyway, so time wasted. And maybe if there's a contract, you have your contractor and your diverse team scoring, it may eliminate some of the issues that we've had in the past.
I guess I just look at it and I think in the end that we can, the issues that came up previously can come up in this same scenario, that somebody says, hey, the amendment talks about us being the one to do it, so we've got to bless it, but if we're not doing the work, how do we bless it?
I thought that was a reason for doing this, so we would eliminate those. Is that correct?
Well, but I think the issue with that is we ultimately have to vote on who it's going to be. So the question becomes, if we just take the list and they've ranked everybody already, we're either blessing it, or we've got to review it, and then if we're reviewing it, what are we going to do with that? I think that's the hard part.
I got a lot of mixed feelings on this one.
I do too.
My sentiment tends to go with you to do it, but there is you're still getting the time constraint of it. Between now and, November, I think 2 of us come off. And I don't know, I'm kind of wanting to hear more discussion, because I've been waffling back and forth on it. I tend to favor what you're saying. I like a little bit more what you presented just now, particularly about if they've run out 5 scores, because that's been a big concern of mine. I mean, you throw this into one person scoring it, and if you don't do 5, then you downgrade the bonus points, which really had a huge impact on who won the cultivators, because you got the bonus points times 5. You got 5 rounds of it. But I'm more encouraged about what you just said, in that that there are still going to be 5 people voting it out. I think that's important, because it's not a one-person job. I mean,
It's not.
So I'm a fence rider right now.
I'm sorry, if you've got comments,
Go ahead.
I'm not a fence rider. I know where I stand on this one. I think the amendment set it up so that there were 5 commissioners. The top priority for what we were to do is to score the applications and make the selections. I think that's our job. And unless we're gonna review what somebody, if somebody wants to knock it down some and give us less to review, well, that's one way to do it. But I think in the end, we find a lot of safety and a lot of even just legal authority, and we're the ones to do it. And I don't think the going on and off is as big a deal as we think it is.
If we're not through it, then you, Commissioner, just here's your stack of papers. Even I wish we'd had started. I wish we'd have rolled straight from March and gone through, because
We'd be done.
It's July. It's a tremendous amount of work, as we all know. We all did it. It's a lot, probably more work than we probably realized. I remember that going to that. Last weekend going in and thinking, well, I can get some. It's
a lot of work.
It's an eye opener. Yeah.
And we need
And we have a limited amount of time now. I was very confident in March that we're going to, and then all the other stuff happens.
And I think the issue that I would just raise to the commission is this. The nice part is we've elected to do it by zones. Each zone is independent of each other. So to the effect that we don't get all 8 zones done by December, there's, the Constitution already provides for new commissioners to be appointed. There's a process. That's a constitutional process. And to the effect that somebody different, if somebody wants to argue, well, some commissioners graded these, first whatever zones, and someone does that, they have that same argument if we shop this out to somebody else.
As it should be. You got 5 people, you're going to have variability in what people like. So I'm a fence. Who's like strongly for third party in this.
Well-
I want to hear some arguments to the other side, because I'm kind of on
So part of this.
Travis's side of the fence here, and I want to hear the other, like, I want to hear some people that feel strongly the other way. Would be nice.
The way that I see it is, when we first started this, we were trying to decide, are we going to go a lottery or a merit? And in a lottery, we wouldn't be scoring anything. So, to me, our task on this commission was to create rules around the licensing process, to create a rubric for it to be scored. And at that point, the scoring should be able to be clear enough for people to read our rubric and score the applications. The problem that I have is, if our rubric is not clear and our rules are not clear, then that would be the problem for us having to go not be able to hire someone else. If our rules and our criteria are clear, then we should be able to hire this out and let someone else grade these applications. So that's why I think that
I think the
it's.
rubric is clear.
I do too, which is why I think we can do it.
I think it's very clear, and I guess my problem is that scoring applications, and then after you score them, they're gonna be pulled out, you know. I just have a problem with that. I just want someone, you know, I prefer someone else now to do it based on the things that I've seen that's happened recently. That's my opinion on it.
And I'm for putting it out for bid and doing it that way. And the reason being is, it took us what? We got these things in December, and then we're looking at the end of February, and we can get it done in what, 30 days? And once we get it to them, so.
That's the way this is written, and
Right.
with monetary penalty if they go beyond the 30 days.
So,
They're gonna be doing it all day.
Yeah, no, they're going to do it quicker, and we're going to be able to do it. There's no two ways about that, because we have jobs.
and I just think that it helps get everything done and get the product out to the people.
Move this process along.
So is everybody prepared just to bless whatever the consultants say? Whoever the consultant ends up being?
I think if we do it,
we
we
have to
do it. I mean,
choose
if
the
we do it,
consultant,
to me,
right?
if they got
No,
five
we don't
scores.
get to choose the consultant. That's the problem.
Yeah, but-
We shop this out with this, and low bid wins. Am I correct? So
As
we don't-
structured, yes.
So we don't get to pick who it is. We don't get to know who it is. Am I correct? I mean, we get to know who it.
Yeah, I was gonna say, I
You're
don't-
going to come to us and say it's XYZ company, and they win the bid, and they're going to start, right?
Well, I mean, I believe ABC would look at it, and yeah, the low bid would be the winner, would be the awardee. Excuse me.
So there wouldn't be any discretion on us to say, oh, okay, now I know who it is. I don't know that we want to go that route.
If you went that route, the issue is that then it would become much more time consuming. If what you're doing is getting into a different procurement vehicle, if you will,
Different process.
a different process. It's closer to what we would call a request for proposal, where price is a factor, but so are qualifications and you know, whatever other factors that are important to the commission. So you're getting into a different procurement process, which in that case would become a little bit more time consuming.
But with that process, that would allow us to like know who it is and have like 3 proposals that we could all vote on. We like Group B for whatever reason.
If it was a request for proposal method, then it would be scored. There would be criteria set up, qualifications, things like this. It would be scored, and whomever was doing the scoring, whether it was Commission or ABC, I'm not sure, would then see all of the applicants and then would score accordingly with a qualified team doing that. And if that was the commission, I mean, this would have to be sorted out. So exactly who would do all of that, but that's the process. So it's a much longer process because the qualifications have to be drawn up. The cooperative was the fastest vehicle.
It just has less control.
Because much of that certification, if we can say it, the qualifications, that sort of thing, of these contractors has already been done by a different state entity. And so now you're just putting out the specific scope of work necessary for this and going from there. But if we are going to go into a longer process of picking the qualifications and scoring and this sort of thing, then we're really somewhat moving over to a different process where we would do the solicitation and move away from the cooperative. So it's just a longer process. It can be done, but it's a longer process.
When you say longer process, I don't have a grasp on what that looks like. Are we talking 90 days, 180 days, a year, what?
The RFP process, I think that you're alluding to because of your questions about qualifications and having discretion in that sense. It's not just a price. I mean, 90 to 120 days would be pretty fast. It's just a long process.
Do we know the cost of a contract? Any range? Do you have a range? I know it's low bid, but you can't. Do you know any ranges or something like this?
Not this. I mean, we're all breaking new ground here, right? So I would be hesitant to give a estimate of what we thought this was going to cost. I don't know if you've had any discussions about that.
I don't think that they were, I think it was just kind of a ballpark. I don't think anybody has enough experience to know what this would cost.
I just think, I mean, even there, we're going to go spend taxpayer money just saying, whatever it costs, here it goes. I mean, we might as well be in Congress spending money just like that. I don't think that's part of our role. I think our role is to come in and grade it. And I know it's a lot of work, and my wife is probably mad at me right now for even suggesting it because she's the one who says turn off the lights. But it's the way it goes, and I think that's our role, and I think that's what we should do. I at least have opinions on this. If you can't tell.
I got a lot more sentiments on your side of the argument, but a question on the last section here. A project manager overseeing the project next to state's point of contact. I mean, would that not be like Dr. Tillman is? I mean, what do they mean a project manager? Is that something that would they not?
It'd be procurement.
Procurement. Okay. Just kinda wondering.
No, it wouldn't. It would not be OSB. And that line in particular is really just trying to ensure that channels of communication are open, and that there's a contact point on the state side, and there's a contact point on the contractor's side.
So the process would be the same. Everything would go through ABCs. They'll meet minimum qualification, and then you guys would send it to the procurement.
The dispensary, I mean, you've already got Zone 1, so we're through that process.
Right. But we didn't have this procurement scope of work.
Well,
planned.
right, but the procurement scope of work is only written for Section E. They're literally stepping into the shoes of the commission to score the merit portion of the applications. So it's not to vet anything else but the merit criteria.
ABC, y'all would still do the bonus points, right? ABC would still.
We could. I mean, if you want somebody else to do it, somebody else can do it. But yeah, that would be.
Well, it seemed like they'll do it for the. I mean, that would at least.
Sure.
I
Yeah.
don't think it's that hard to do.
Yeah.
You know, it's just plugging it in.
It's like,
Yeah. Do you meet that or do you not meet that?
The contact on the state side, it doesn't necessarily have to be anybody at ABC. If you want it to be Dr. Tillman or you want it to be any one of the 5 of you, it's fine. Because, I mean, again, it's just a project manager communicating with someone at the state to make sure that they're getting things done on time.
I would just think that they would, that our chair would be, not to throw you in the
It
fire
can be
here,
written
but.
however, right? I mean,
But
you
that
know.
statement is not talking about this side, it's talking about the
Procurement
other
side.
side.
I
No,
understand
not
that.
procurement, the contractor side.
Right.
But there
That they
would-
must have a project
And they
manager.
would have to
Right.
have
The
the
project
same-
manager is on the
on theirs.
contract. It's just
Yeah.
ensuring that there's a project
Communication.
manager. There's someone overseeing the
Somebody-
contract and the work, and that project manager is communicating with some contact on the state side. I mean, it's a very just basic requirement to ensure that there's a communication channel.
How long does it take? I mean, I know we're giving them 30 days to do it, but what's the rest of the timeline look like?
You mean to get through this procurement process?
To get, how long does it take to get them to start their 30 days?
Right. Last time we had said 30 to 60 days, and I think with the scope of work having been substantially completed, or at least thought through based on the discussions with this group last time, I think it would be closer to that 30-day mark.
In order to get all the bids back?
It depends on how much time we would want to give, but 30 days is fairly standard for the responses to come in. Give for the responses to come in. So that could be shortened if need be a bit, but 30 to 40 days I think is a fairly reasonable and realistic timeline to get the scope of work issued, to allow them time to then respond and then to name the awardee.
So when you say name the awarding, do we get those results back, or do
They go to ABC?
they go to ABC?
Whoever you write in the contract. If you
Right. So this is that depends on what you all want. OSP is not trying to insert itself as doing that job. I'm just here to advise you on the process.
And we appreciate that.
So, so that depends on you all and how you want that to be handled.
So basically, would it come to us first, and then we have a meeting to discuss it, or do we come into a meeting and just do a flash fire?
Well, but the question is, if we go that route, we don't I mean, there's not a whole lot to discuss, right? I mean, it's...
Right. I
We
mean,
have to accept their scores
it's being
as-
set up to where the low cost,
Wins.
the lowest price wins, right?
I mean, if we're gonna hand it over, we just hand it over. I mean, there's no reason for us to try to, I mean, you wanna talk about, I mean, that's just redundant work. Either we do it or either we
Or
do
they
it.
do it, or-
Or they do it. I mean, and I just don't know.
And I think the problem is, if we let them do it, you know, that is the decision, right? That's the decision of all the dispensaries, because we've turned it over. I just don't think that's right. We're gonna shop out our jobs.
What do you think?
I'm just looking at timeliness and, and if it's truly objective scoring, I mean, there's no reason not
The
to.
rubric tells the story.
Right. And but we still have the final decision.
But what are we gonna do at the end? I mean, I don't know.
There's going to be a high score and there's going to be a low score.
Right?
We'll look and see if they I guess if they met the qualifications, if they're where the scores fall, and the top.
But what do we do if we look at the top 6 in zone 1 and say, I don't think that number 4 should be where they are. I think number 5 should be where.
Why would you
number
look?
4 is.
Why would you say that?
Because I'm the one who has to be the one to vote.
But I mean,
Yeah, I mean, at this point, we're-
then
we're-
why would you?
that we're-
That's like you need to score it then. I mean,
Which is my point.
So, it doesn't make sense for you. You won't be able to do, am I correct? We get these scores.
Well,
and
yeah.
He can't go back and say, well, I want this one to be a higher score. You can't do that.
You're
The
right,
scores
yeah.
are the scores, and that's what I've always been saying. You score it, and that's the scores,
Yeah, if we hand it
but,
over, I think
you know,
we hand it over.
You got to be fair about this, guys. You got to score the applicants based on what you have. You give the scores, let the law, whatever, figure it out after that. That's what we were supposed to do. Now, when you start changing stuff like we did today, I'm just like, this is crazy to me. We're either going to have someone score them, that's the scores, or we're going to score them, and that's the scores. That's what I understood.
Well, but I think we
Right.
did what we were supposed to do. We came in here and we looked at it, but we had to look at it. We didn't blindly take what ABC gave us. We said, we want to know why, we want to review them.
Mhm.
The ones that we had issues with, I mean, I looked at this application, and if,
Well, I'm just talking about scores. Score the application based on the information that you have on the application. And so you can't change you can't go back and score it if this procurement group has scored it and go with your score. We can't do that.
And, yeah, no, we can't, yeah.
So that's, because you're saying, what if I don't like, I think 5 should go before 4. If you score, you can't do that. Can he?
I mean, I don't think that's what's anticipated. You're
Right.
putting this in the hands of,
Right.
you've written a framework to get the
Right.
people you think can score it.
We can't
They
allow
score it
any
and you're
The
done.
score is a score, and, we
But
can't
then-
change the scores.
but then my problem then is, we were talking about, hey, it has to be the commission who makes the ultimate decision. I think we're abdicating that responsibility at that point. That's my
The
point.
commission is not making the decision on the score if you get someone else scoring.
Right. And I think under the Constitution, we're supposed to be the ones making the decision. And that then becomes the legal challenge that's gonna shut the whole thing down. That's my opinion. And I know I'm not the commission's lawyer, so, we can ask others that part. That's my view as a commissioner. It's not legal advice to the commission, but I think that's my problem with it.
Danny, what do you think about that? I mean,
You have a comment, Danny?
The Constitution doesn't in any way prohibit the hiring of a contractor to assist in scoring, and you all did just amend the rules to give you that authority. So there's nothing legally that precludes you from hiring a third party to do this, if that is the will of the commission.
I move we not leave here without a vote. We got to vote on, I mean, I've been thinking about this probably more than I should have since it first came up. I feel a little more comfortable
I was all for it,
hearing you
but
say
not
that.
now. No.
You're all for it or not,
I'm not for scoring.
well, then,
That's my opinion.
unless we think there's going to be
So what,
I'm probably the
I mean,
biggest
it's
fence rider,
discussion.
but I think we need to get a vote out and,
You want to put a motion?
I'll put the same motion out that I put out last week, which is that the commission.
Now that you have the rule passed. Yeah.
Well, and the point is, I think there's plenty of things we can use the rule to hire a consultant if we need one. I think there's other discussion we can have on this, but I think as the commission, our biggest job is to decide, are we going to score this stuff or not? And I think it's our duty to score it. So my motion is that the commission resume scoring of all the dispensaries. And, we start with zone 1 and we can talk about how long we're gonna do to take, get it done, but we move forward. So I say the commission's the one doing the scoring.
Anyone want to second
Mike, I'll second it. Fence rider, but it's not gonna pass, but I think we know it's going down. But I think my sentiment is, but I'm not that hardcore either way on it at this point, but I'll second it.
that? Any further discussion? Let's call for a vote.
I vote aye.
Aye.
No.
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 All right. So let's get a motion.
To kick it to third party?
Mhm.
I'll make a motion, send it to third party.
Second. And
Any other
for
discussion?
discussion, can we clarify that we would use the procurement scope of work included, just for that clarification?
Yes, I mean, they're gonna have 5, I'm not big on that math, I just think that's important. But
Yeah.
And I would ask for one more point of clarification. Who do you want the contact to be for the commission?
Well,
You want it to be you,
I
Dr.
think
Tillman?
Rhonda would be the natural.
I think
Well, I guess, side,
Okay.
yeah.
Okay.
sure. So we have all in favor?
Aye.
I'm opposed.
I'll be opposed with you there. It's gonna go, but that way you'll be completely by yourself, Travis.
Doesn't- Thank you.
I just think that's a hard call.
Any other business?
How fast will this go out?
It's been basically written.
Yeah, we're prepared to get it out in the next, certainly the next couple of days, wouldn't you say? I mean, it's essentially prepared and ready.
And so what's the next step the commission needs to take at that point? Is there one?
I don't, with regard to this, I don't believe there would be a next step. If we've approved scope of work, the
Okay.
criteria you want in the scope of work, it'll be this plugged back in, with Dr. Tillman as the contact. And
With the,
I think we move forward.
No, we move forward, yeah.
oh, I'm with you on the other thing.
Yeah.
I think you did. I just think that should have been done illegal.
Mhm.
So at this point, we should, how long will it take once we have the bids back? Let's say 30 days? Is that what we're anticipating, or will we give that as a closing time? Do we need to decide that or not?
I don't know as to whether they need to decide that. I mean, because that is at your discretion.
Can we meet this group after the bids are gone through?
So there is a kickoff meeting once they are selected, where they can either appear by video conference or in person. I think if they appear in person, it does raise the cost, because that's travel.
Well,
But
we just want to make sure that they, if they have any questions about our rubric, I mean, we're
Sure.
a part of this, and
Yep.
I'm just not going to just say, I don't think we should just say, hey, okay, we don't want to meet you, we don't want to know anything about you.
Right.
But they need to understand where we've been and where we're going and what we
And that's
are
accounted
hired
for.
That's accounted for
here,
in
kickoff
the
meeting.
kickoff meeting.
And video conference is fine. I mean, we
Okay.
can do video conference anywhere, but
Okay.
we would like to review our rubric and see if they have any questions, so
Yep.
they can meet us as a commission. I mean, they need to kind of see who we are and what
Right.
we've been doing.
That's built, they have to agree to do that already
Okay.
on these qualifications, to coordinate and initiate a meeting, and then also abide by your standards of scoring.
Right.
So, so what is are we doing 30 days? Is that what,
So,
the time we're putting it out for bid?
30,
That
I
would-
think you missed.
that would be our
30 days.
recommendation. That's fairly
And then we would
standard.
call that, now, this video conference, is that open? Will we do it here, or is that open to the public, or is it?
If it's just you, I don't know that it would be necessarily open to the public. If it's the entire commission, it will absolutely have to be open to the public, and will be open to the public.
So, I mean, it's all been open to the public anyway. I mean, I would
Sure.
rather them,
Yeah, I mean,
the whole
I-
commission instead of just me. We all have,
Yeah.
yes, I prefer that it be open to the,
Yeah, that's your call.
Yeah.
As the project driver, that's your call.
okay, I call that. Sorry, guys, y'all need to be there.
No, that's good. So
Um,
how long,
so-
or go ahead, sorry.
So I was just wondering if we can, 30 days from the date, that means that we'll be setting up another meeting. And so I guess you would give us some details on that. Or should we plan a date right now, 30 days from today?
Well,
How long will it take once you get all the bids back?
so that should be very, very quick. I mean, same day, or certainly within a day, because it's just going to be looking at pricing and ensuring that those minimum qualifications are met. So that should be immediate. As to whether we should schedule the meeting now, I'll defer to the director.
Let's just, I think, wait until we know an exact, precise timeline from when we've sent them out, and then we can get in touch and figure out schedules for a meeting.
Okay. We're adjourned. Thank you. That's what I said. We should I don't care what happened.
I mean, like, you're here.